Morristown Housing Authority versus Little, for me personally, has been the highlight of my legal services career. Kathy Little, single mom on AFDC, 5 minor children. Her rent is $125 a month. She owed 1 month's rent. So the Housing Authority of Morristown, who owned and operated her apartment building, file an eviction proceeding just based on non-payment of rent. Well, she doesn't show up in court. So the Housing Authority gets a default judgment for possession. They get a warrant of removal. She's locked out. Her and her 5 kids are locked out. She gets the $125. She offers it to the Housing Authority. They don't want it. They allege that there's drug activities going on in her apartment, so they don't want it. She comes to our office. So we file an order to show cause to get her back in. The first application I bring up is denied. The reason why it was denied is the judge who was sitting, hearing the application said, well, she's been locked out, there's nothing I can do. And I then scurried and did a memo pointing out to the judge that there's a statute that allows the judge to give relief within 10 days of a lockout. So when I showed this to the judge, I had to file another order to show cause. So when I showed this to the judge says, okay, fine, I'll let her back in, and we set up a hearing date. So we set up the hearing date, and now it's a different judge, and the judge says to the Housing Authority, it's a non-payment of rent case. She has the money. I got 5 kids here. You're a Housing Authority. You take the money, you let her back in, case is over. Housing Authority says, well, Judge, we think there's drug activity. Judge says, it's a non-payment of rent case. It's money, you take the case. Okay. So the Housing Authority won't let it go. They file an appeal to the appellate division. So I was feeling pretty confident because I had won. And we go before the appellate division, and the appellate division reverses because the judge below had based his decision on a court rule that allows a trial court to give relief from an order or a judgment. The appellate division said the only basis for relief is a statute that allows for a hardship stay and doesn't allow for reversing a judgment for possession. So I was, and just a little funny aside on that was, there were 2 judges that heard the argument, the oral argument. So after the oral argument, but before the decision, they send us a letter, myself and other counsel, and say, do you mind if we add a 3rd judge to our panel to decide the case? So I'm figuring they must be deadlocked. So they need a 3rd judge. So I consented, and so they add the 3rd judge. I get the decision, it's not 2-1, it's 3-0 against me. And I felt like saying, if I could ask, why did you need the 3rd judge? You just had to rub it in, you know? So anyway, So I get the decision, and it's horrible, because what it means then is tenants cannot get judgments, eviction judgments, overturned, reversed, vacated, even upon paying the rent. The most they could get is a hardship stay. That was the essence of the judgment. And I remember calling the housing authority attorney up, and I said, I have to appeal this, file a petition to the Supreme Court. I said, I can't just let this. And she got very upset that I was going to do that. So anyway, the Supreme Court took the case. As you may know, they take very few cases, maybe 5% to 10%, maybe even less, of all the petitions that are filed. So they accepted the case. Dave Sierra from Ellis&J, who at that time was the housing, I call him the housing director of Ellis&J's housing unit, filed an amicus brief and argued and did an excellent job. But it was such a great experience. I mean, it was, I worked really hard on it, but I was really prepared, and I was prepared. I was prepared for everything the justices asked me, except the first question. And that was a lesson to me, because the first justice who asked me a question, I had done moot court with attorneys from Ellis&J in prep, and we never touched upon that first question. And the first question was, well, counselor, isn't it true that there are many indigent people on waiting lists, waiting for apartments in public housing? So why shouldn't we take that into account in deciding whether your client has a right to stay in this housing after the appellate division made his decision? And after stammering a few minutes, it was like someone hit me in the back of the head, and I just said, that may be true, but we're talking about Ms. Little and her 5 children in this case, and not the other people on the waiting list. And after that, I was fine. And Dave did a wonderful job. And we took a 3-0 decision against us and turned it into a 6-0 decision for us. So that was Little.